Bismillahirrahmanirrahim. Good day and Assalamu alaikum. We are from Group 1. Today, we are going to critically discuss between the difference between the traditional contract, the smart contract, and the electronic contract. So, let us start with the introduction of our group members. Our group consists of three of us, which is me, Faris Dani Rizal. We have one Nur Ain Batisha and Farah Nadia binti Matno. Before we critically discuss the difference between a normal contract, a smart contract, and the electronic contract, we need to understand the introduction of the basic type of contract or the traditional contract. A contract is an agreement that is binding towards the party. The contract is governed by its sole statutes, which is the Contracts Act 1950, and there are few elements of a contract that need to be fulfilled and required in order for the contract to be valid and legally enforceable. So let us start with the basic elements of a contract. The first element of a contract is offer and acceptance. Offer and acceptance, we can look at the definition under Section 2 Clause A and Section 2 Clause B of Contract Act 1950. An offer is when someone signifies his assent to do or to omit himself from doing something. Acceptance is when the person whom the offer is made accepted the offer. So, for example, if I were to offer someone to buy my phone, that is constitute an offer. And when that person agree to buy my phone, that constitute an acceptance. The second element of a valid contract is consideration, and consideration can be defined under Section 2, Clause D of the Contract Act 1950. Basically, it is something that is exchanged between both parties in a contract. So, we use again the example of buying phone. In these circumstances, the consideration is that the buyer will get the phone and the seller will get the money from the phone. And thus, both of the party will get the benefit from the contract. And that is what we call as a consideration. Next, the elements of a valid contract is intention to create legal relation. As we know that a contract is valid and enforceable, thus the contract will be binding to the parties to the contract. And thus, if a party is found to be breaching the contract or to non-perform his side of the contract, it will make the party liable for the breach of the contract. Next, the elements of the contract is free consent. Under Section 13 of Contract Act 1950, explain that every party to the contract must agree and must be willing to be a part of the contract. And under Section 14, it explained that if the consent is obtained by either fraud, misrepresentation, or by undue influence, the consent is said to be not free and the contract will be voidable. And last but not least, the elements of the contract is legality. A contract must be legal in order for the contract to be valid. Under Section 24 of Contract Act 1950, explain that a contract that's either immoral or against public policy is considered as unlawful and thus will cause the contract to be void. So that is basically the elements of the traditional contract. However, as time goes by, as time evolves, right now we have so many types of contract that are evolving. As we speak today, we have new type of contract which are electronic contract and smart contract. And such, we are going to discuss on how this type of contract is different from the traditional contract.
Assalamualaikum and hi, my name is Farhana. My metric number is 291371. So today I will be presenting about smart contracts based on how they work, the benefits and challenges, and their legal recognition in Malaysia. So what is smart contract? Smart contracts are digital agreements written in code and executed automatically once predefined conditions are met. Unlike the traditional or electronic contracts, they don't rely on human intervention and think of them as highly secure and self operating agreements that live on a blockchain network. So we move on to features of smart contracts. There are four features of smart contract, which is automation, transparency, immutability, and also efficiency. The automation, which is tasks are executed automatically without intermediaries. Second point is transparency, which smart contracts are stored on a blockchain. They are accessible to all parties involved. And the second point of features of smart contracts is once they are created, they cannot be altered. And the last point of smart contracts is it provide efficiency, which they streamline the processes and will save our time and costs. So we move on to the next part, which is legal recognition in Malaysia. So the issue here is whether smart contract is recognized in Malaysia. So in Malaysia, smart contracts are not yet governed by any specific laws, but supported by existing frameworks such as Contract Act 1950 and Electronic Commerce Act 2006 and Digital Signature Act 1997. So the first act is Contract Act 1950, which ensures they meet basic contract elements such as offer, acceptance, consideration, intention, and etc. The second act is Electronic Commerce Act 2006 and Digital Signature Act 1997 support the use of digital records and signature, providing some legitimacy. However, the legal landscape for smart contracts remain a work in progress in Malaysia. So we move on to the next part, which is the benefits of smart contract, which is provide cost efficiency, security, and also speed. So the first point is cost efficiency. So we explained about traditional contract first. Traditional contracts often involve intermediaries like lawyers or brokers to draft, review, or enforce agreement, and this may add time and expenses to us. Meanwhile, smart contracts eliminate these intermediaries because the terms are programmed into the contract itself and executed automatically, and it reduces the administrative overhead. The second benefit of smart contract is the security. Smart contracts are built on blockchain technology, which is decentralized and use encryption to secure data. This makes smart contract resistant to tampering and hacking, ensuring that the agreement remains intact and trustworthy. And the last point, the benefit of smart contract is the speed. Traditional contract processes such as negotiation, approvals, and manual execution can take days or weeks or months. Smart contracts automate these processes. Once the conditions are met, execution happens instantly and it saves our time and increase the productivity. So we move to the next point, which is challenges and limitation in smart contracts, which is it provides legal ambiguities, technical complexity, immutability risk, and also it has jurisdiction issues. So for legal ambiguities, smart contracts lack specific recognition in Malaysian law, although they meet basic contract elements such as offer, acceptance, consideration, and etc., it is unclear in complex cases. For example, what happens if there is a dispute over a term encoded in the smart contract and courts may find it challenging to interpret the code as a legally binding term. So the second challenges is technical complexity, which is writing and implementing smart contracts require expertise in blockchain technology and coding, and many small businesses and individuals may lack the financial and technical resources to adopt this technology, and this creates a barrier to widespread use. And the third challenges of smart contract is immutability risk. And a key feature of blockchain is its immutability, which means once a contract is deployed, it cannot be changed. And this rigidity can cause problems if there is an error in the contract's code or if unforeseen circumstances arise. For instance, a simple typo in the code could lead to unintended consequences. And the last point of challenges of smart contract is it has jurisdiction issues, which is smart contracts operate globally on blockchain, but each country has its own legal system. And when a dispute arises, determining which country's law apply can be complicated. For example, if a Malaysian business enters into a smart contract with a partner in another country, different legal frameworks might make enforcement difficult. In Malaysia has been making strides in adopting blockchain technology. Initiatives like the National Blockchain Roadmap signal a government push toward digital transformation, and smart contracts are natural fit for this agenda, especially in sectors like finance, supply chain, and also trade. There are few steps for wider adoption of smart contract. First one is legal reforms. Laws such as the Contract Act 1950 and Electronic Commerce Act 2006 needs updates to address the specific characteristics of smart contracts, and new legislation could define how smart contracts are validated and enforced. The second step is capacity building. Training programs for legal practitioners, businesses, and developers can help them understand and use smart contract effectively. Universities could incorporate blockchain and smart contract programming into their IT and law curriculums. So the last step is business application. For example, industries like banking, insurance, and logistics can pilot smart contract project to explore their potential. For example, insurance companies could use smart contracts to automate claim processing.
My name is Wanur Ain Batrisha binti Wan Abdul Halim and my matrix number is 291286, and now I will be presenting about electronic contracts in Malaysia. Firstly, what is an electronic contract? So, electronic contract is commonly referred to as e-contract. It is basically a legally binding agreement that is created and executed through electronic means. So, these contracts, they eliminate the traditional use of paper-based documentation, and they use digital technologies for their formation, execution, and storage. So e-contracts, they are widely used in online transactions including e-commerce, software licensing, and digital services because they enable these parties from different locations to enter into a contract. However, e-contract, they must meet the legal requirements of a traditional contract, which is offer, acceptance, intention to create legal relations, considerations, capacity, and legality to the contract to be enforceable. So an example of e-contracts is, when online users, they accept the terms and conditions while making an online purchase or when they are signing up for services online. In Malaysia, we all know that the law that governs contracts are the Contracts Act 1950, but as for electronic contracts, we have specific law that govern it in Malaysia, which is the Electronic Commerce Act 2006 and also the Digital Signature Act 1997. So in the Electronic Commerce Act 2006, or known as ECA, this act, it outlines the requirements for the formation of a valid electronic contract under the Malaysian law. And one of the key sections that was mentioned in the act is section 3, which mandates the parties to the contract to consent to conduct the transactions electronically, and this consent can be explicit or inferred from conduct such as placing orders online or providing their email address. So besides Section 3, Section 6 of the same Act also established that information in electronic form cannot be denied its legal effect or enforceability merely because it is electronic. So this supports the legality of electronic communications in contract. And besides that, Section 7 of the same Act also affirms that proposals or offers and their acceptance can be communicated electronically. So these sections, they ensure that contracts formed through electronic messages are legally valid and enforceable. And lastly, Section 8 of the ECA mentions that the documents that is stored electronically that is required by the law must be accessible and intelligible for future reference and include details such as the origin, timestamp, destination of the messages. So besides the Electronic Commerce Act, there is also another law that is related to electronic contracts in Malaysia, which is the Digital Signature Act. So this act, it provides a comprehensive legal framework for the use and validity of digital signatures in Malaysia. This act, it ensures that digital signatures are legally recognized as equivalent to traditional handwritten signatures, especially within electronic contracts, provided that certain conditions are met.